So, you know, this is one of those that's tough because you disagree with the outcome, but the reasoning is relatively sound. And so, like, it's one of my favorite Justice Scalia quotes was, if you agree with the outcome of every decision, you're a bad judge. I'm looking at Kagan's concurrence right now because that's one that would kind of speak to me. It was joined by Sotomayor. And it looks like she acknowledged here the law that as it's applied is viewpoint based, and that's just not something you can do under a First Amendment scenario. So the Colorado only allowed one side of the counselors to basically operate. So the therapist can say, I accept your orientation, but they can't say, I will help you change it. And the state is giving preference to the viewpoint that, well, I just accept it and I'm going to work with you under those operations versus somebody who comes to them and says, this, I don't want to feel this way and I want to change it. Now, though, those therapists' speech is regulated. And that's what I have a problem with, is if somebody comes to you and says, this is the service I want you to provide for me, Colorado is saying you can only do this service, you can't do this other service. And I haven't gotten to Jackson's dissent yet, but that might be interesting. I imagine it's going to be focused more on well, this is still medical treatment and it's a medical regulation, not necessarily a speech regulation. But I think where they have a hard time coming over is Colorado's law basically says you can say this, but you can't say this. And if a practitioner's viewpoint is the opposite of what Colorado has endorsed, then Colorado is compelling their speech or restricting their speech, and neither of those are acceptable under the First Amendment.
See, and I agree with you on that. And that's why this one was a little bit harder for me. I see where you're coming from and I don't disagree. And it's an outcome issue for me. While, I think there's a time and place for everything, right? Like everybody, wants to just be one thing or the other. I think there is a time to consider outcomes here. But I agree with you that if it's altering her speech, and if somebody genuinely comes to her wanting to change, they shouldn't be prevented from doing that. My only issue was here you have cases involving minors, and then that might be parental influence more than theirs, which is why I was like, oh, this is such weird, shaky ground in where like the child stands in all of this, and parents ultimately have the say. So that it was an outcome worry for me, but I get where you're coming from because I can't disagree with their consensus. I can just say I don't like the outcome of it.
Yeah, and I'm looking at this, and I hadn't dove too much into this one before, but the state's position seemed to be that it was regulating the professional conduct, not the speech. But then Gorsuch points out that like counselors could offer acceptance, support, and understanding for identity exploration and could assist a person undergoing gender transition, but could not say things to help a client reduce same-sex attraction or align with biological sex. And so when you're basically saying that this is the viewpoint that the government prefers, then and you can't say anything that's counter to that viewpoint, it's really like government endorsing a particular viewpoint of speech. And in this case, you know, I hate this topic because it blurs the lines of what's medical versus what's psychological. Not that that's not medical, but also there's a whole bunch of cultural impacts on this, which is why I'm more akin to go along with what Kagan and Sotomayor say, just because I think they're going to bridge that divide a little bit more. Justice Jackson saw the Colorado's law medical treatment regulation. Okay. Licensed healthcare professionals, and so laws regulating speech and laws regulating professional conduct that incidentally burden speech, trying to differentiate those. So yeah, that's compelling too. it's just I think when I look at the way that Colorado wrote their law, they could have done a lot better to make it more professionally focused instead of here's what you can do and here's what you can't do, um, in that vein.
Well, and I think too, like we get decisions like this, and a lot of the information gets super conflated. I don't feel like this is a Supreme Court outright endorsing like some horrifying conversion therapy. I think
No,
this is
absolutely not.
them just saying, hey, your law was crappy. It infringed on speech. Maybe focus on something different that time, to your point. Like, I think the consensus within the medical community is X, but I kind of started thinking about this while you were talking. If we're like some of the position that we take on AB usually is like just let doctors decide. Is it the same case here? You know, is it beneficial to the patient? Is this in the patient's best interest? Da 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 da. And like to your point, if somebody comes to them, even though I don't agree with it and I don't think it's healthy for them, it doesn't really matter because they're in charge of that and says, hey, this is what I want to do. Colorado's law banning that is starts to become problematic. So yeah. I'm still waiting on this to start. It's probably going to be a minute. It's like a 60-page decision. So we shall see. Another one we got was Cox v. Sony. That one was pretty based. They were just like, yeah, no, you can't cut off Cox or sue them for copyright. And I was glad that that was the outcome because,
It's like, how many cases do we need to reaffirm that content providers are not responsible for their illegal actions of their subscribers?
well, and the thing was, it was like, during that case, like they were like, okay, well, what if somebody in a hospital does it? We're supposed to cut off the whole hospital because like one person within the hospital did something, you know, like it was just, it was a terrible case and listening to arguments was hilarious. And I only listened to the last half too, because I wasn't going to even cover it at all. But it turned out to be more interesting than I thought it would be. And people were like, oh, this is what's going to happen. And I was like, dude, they're going to tell them you can't do that shit. Like I had read it and I was like, yeah, this is not going to work out how Sony wants it to work out. So good
Yeah,
morning, Bryce.
I was just looking at because Minnesota passed a conversion therapy ban back in 2023, and I was looking to see what the how the language um, applies. And Minnesota, I think, crafted theirs more carefully, which is why they probably weren't sued. Is Colorado basically says you the only thing you could do is support or assist gender identity exploration. Like you can't do anything else. And what Minnesota says, as long as it does not seek to change their identity or orientation. And so I think that that's important there because if you're a counselor, you shouldn't be trying to push a particular outcome on your client. You should be helping them explore and let them come to their own conclusions. Help them
Yeah.
work through the things that they're concerned about, work through their thoughts, and let them come to that conclusion. So I think Minnesota's is much more neutrally that way. It doesn't say the only thing you could do is support, assist, and assist, which is Minnesota, which says, hey, you just can't try to change it on their behalf, and so that goes into these kind of more coercive therapies that we've seen from kind of these religiously aligned ones where it's pray the gay away or hit you with a Bible until that. So I think that Colorado could probably get to a ban if they did something like Minnesota with some more neutral language and not basically trying to compel the speech of particular practitioners.
Yeah, that's interesting that you kind of put that nuance in there because like so Colorado's law was just saying you can only do this and this is all you're limited to, right? So
Yeah.
but whereas Minnesota is like, well, you kind of can't really do, but they weren't more nuance to it. Yeah, I like
Well,
what you're
there's
saying.
Minnesota is more aligned with like professional conduct. Is
Yeah,
you can't try to change your client's identity because that would be professionally
yeah.
inappropriate. You're projecting your own, beliefs onto your client, whereas. So Minnesota's just says you can't do that, and that's much more aligned to like rules of professional conduct, professional standards, versus what Colorado did, which is says you can only do this when there's at least some other viewpoints that are medically relevant that might enter into that. Like for example, and again, I'm not saying this happens, but I'm going to an extreme to kind of test the arguments. In Minnesota, if a 6-year-old comes up and says, I think I'm a boy, your counselor can say, okay, well, are you really sure about that? Is that, what's making you feel that way? Have you thought about this? Whereas like in Colorado, under their language, it says, nope, if they think they're a boy, you have to accept that and you have to endorse that viewpoint. The only thing you could do is provide support or assistance to that viewpoint. So I think I think Minnesota's aligns more with what you kind of expect from professional standards.
Yeah, which is just allowing the exploration to be there and not forcing one or another opinion, right? Whether
Right.
it's religious or if indoctrination or whatever they're calling it, yeah, that makes sense. Like that's why I wanted you to come up because these cases are always a little bit more devil is in the details kind of thing. While I don't like the outcome, I can certainly be like, I don't want people's, and they picked a good client for this case because some of her stuff was like, look, if a client comes in and wants to change, that's what I provide to them. But if they come in and they don't want to change, I also provide them services. So that when
They,
I remember when I was watching it, I was like, that's kind of damning because she's just providing the service the client asked for.
these cases out of Colorado are always tough because they pick really good clients and really good cases. The only one that I wasn't a fan of was the website designer case. That was entirely. So this was the one that didn't want to design websites for
Oh, yeah.
LGBT couples. But the issue was Colorado waived standing at the appellate court level. And so everybody's yelling about, well, they didn't have standing because she wasn't actually making websites yet. This was all hypothetical, and the court shouldn't hear hypothetical cases, which is generally true. But if the respondent waives standing, the court doesn't come in and say, well, we're going to address standing now because that's not before them. So when Colorado conceded standing on that to try to get a merits decision, they essentially waived that argument.
God damn it, Colorado. Jesus. Like, listen, like, I don't think that you should be able to compel an artist to create art. Like, fundamentally, I agree with that. But a lot of the cases that come out of Colorado are concerning, like, the legitimate community and, like, I don't know what Colorado's doing over there, but they're not vibing with this Supreme Court for sure. Like
Yeah.
our Supreme Court is like, does not like Colorado. I never see them succeed in this court.
But also the wins that they get are generally really over amplified, in the rhetoric that's out there. So for like the Masterpiece Cake Shop, for example, bake the damn cake. The when they did that case, it was, hey, you're free to buy any of my cakes that are out here. If you see a cake that you like, you can do that. The issue was, am I forced to use my artistic capabilities to endorse a message that I don't agree with? And the website was along that same vein, is like, hey, I offer web design packages. If you want to buy a theme and a template, you can buy it. but I'm not going to customize this because of that. So Colorado is a lot like Minnesota in that way, where you've got very deep blue pockets that kind of set the tone for the statewide politics, but then you have very blood red areas just outside of those metropolitan areas, and they are like fervently against what's going on in the population center. So that's why I think these cases keep coming up out of Colorado, because Colorado's swinging for the fences, passing all these kinds of things. Minnesota, the legislature's typically been divided, so it's been more challenging to try to get consensus behind some of the more super progressive things, but not in Colorado. Colorado, the way that their population breaks down, they can pass dang near anything they want out of their legislature. The governor will sign it, and then that, I think that kind of breeds these challenges. But going back to my main point, is the wins were always very oversold. It was not the you could deny services to LGBTQ community. It's you just can't be compelled to use your artistic capabilities to create something that is against your personal beliefs.
Yeah, like and that's the thing. Listen, out here in Texas, we vor dire you, okay? Sorry, I sent Law a video this morning. I was laughing about it, but like, it's similar in Texas though too. Like, even though our legislature is very Republican, it's because of like the vast amount of rural area we just have. But like our huge Senate, like our huge cities are all very, very blue. I think Houston is our bluest city. Dallas is a little weird. They kind of go half and half. And then Austin, obviously very blue. San Antonio, a little bit more kind of in between. But yeah, like our bigger cities are blue, but like, yeah, you get out into the rural areas here, it's blood red. So yeah. Oh my God, what are they reading in there? Jesus.
Well, yeah, I mean, you've got Gorsuch reading his majority. You've got Sotomayor or Kagan reading the concurrence, and then Jackson reading the dissent. So it could be a bit.
I swear to God, they have to stop doing this. They're killing me. Get on it, guys. Like,
they stopped doing it over COVID for a while, and that was quite great.
I just want my only frustration with the court. I don't care
We'll
that
hear
they
argument this morning in case
Never mind.
247351, Pitchford versus Cain.
Here. I'm going to do a
Mr.
little bit of
Perkovich?
work while listening in the background.
Mr. Chief
Sounds good.
Justice, may it please the court. In the selection of Terry Pitchford's capital jury in 2006, the trial court grasped and conducted just 2 of Batson's 3 steps after the district attorney struck in succession 4 black citizens. Despite the state's assertions throughout the red brief, the judge never determined the credibility of the prosecutor's step 2 proffers. Had the judge done what Batson demands in step 3, the court would have considered, from the voir dire that single February morning, the prosecutor's absence of questioning about the issues and the proffer's lack of record support and irrelevance
It's
to the
for
case.
dire if you're from Texas.
What is more, proper credibility determinations would have concerned numerous extreme bad faith findings against this district attorney in 2 Mississippi Supreme Court capital reversals published in 2003 and 2000, which held this prosecutor had fabricated prior statements to impeach 4 witnesses who were black, and in closing argument espoused 14 discrete lies about the record. Instead of abiding Batson, Pitchford's trial court careened to opening arguments. When the defense strained to be heard before the jury's empanelment, both about Batson and a fair cross-section challenge, the judge assured her 3 times the Batson objections were preserved. Yet the Mississippi Supreme Court found that Pitchford's defense failed to rebut the proffers and thus waived argument, while deeming the merely race-neutral proffers
Just for
as,
clarity,
quote,
to the best of my knowledge,
substitute for
Batson
Batson's
is
demands.
about
and a sidestep of the
racism
trial
and
court's
preemptory
failure
strikes.
to determine the credibility
Correct.
of the 4 strikes. The trial court's unrectified failings in this prosecution, also riddled with other misconduct,
i.e. it says you
yielded
can't
a
do that.
jury selected with discriminatory taint, which in turn condemned an 18-year-old whose accomplice, according to the state's case, killed the shopkeeper in this botched robbery. We urge this court to reinforce the Equal Protection Clause's guarantees for defendants as well as citizens willing to accept the awesome responsibility of jury service. I welcome the court's questions.
Did trial counsel make those arguments?
Mr. Justice Thomas, which arguments specifically do you mean?
Did the trial counsel make the argument that the prosecution discriminatorily picked the jury or exercised peremptory strikes for the reasons you just stated?
Justice Thomas, trial counsel made the objection timely.
What was the objection?
It was a Batson objection.
Okay. And did the trial counsel has the burden of demonstrating discrimination, right?
Justice Thomas, that's correct.
So did trial counsel do that?
Justice Thomas, trial counsel attempted to engage that process, which entails 3 steps in burden shifting. Unfortunately, the 3rd step did not occur in this case, notwithstanding trial counsel's effort.
What do you mean by that? It didn't occur. The judge decided that it was race neutral.
Respectfully, Justice Thomas, yes, that's all the judge did.
But did the trial counsel offer an argument or evidence that the reasons offered by the prosecutor were pretextual?
Justice Thomas, as the veneer was being released from the court, trial counsel sought to be heard on Batson and a fair cross-section issue, and was told by the trial judge repeatedly that her record was preserved.
But didn't trial counsel subsequently file an affidavit indicating that she did not raise these objections?
Justice Thomas, yes, that's correct. 3 years after the decision that's before the court now, in state post-conviction, an affidavit supporting an ineffective assistance of post-conviction counsel or trial counsel was authored, which
we're listening to a case live right now, guys, but I can go through some of the conversion or the ruling a little bit later after we do this.
What the transcript shows is that Ms. Steiner's what she said is at some point the defense is going to want to reserve both its Batson objection and a straight 14th Amendment racial discrimination. Was that objection raised later on? I mean, I think that's where that's the preface to where you say that 3 times the court said you have that. And I wonder if there was some confusion between the reference to at some point the defense is going to want to reserve and the court's statements that it is, you've already made it in the record. So I am of the opinion that it is in the record.
Mr. Chief Justice, thank you for that question. It allows me to clarify the sort of the goalposts on this question under Mississippi procedure. When the veneer is dismissed and the jury's impaneled, the opportunity to challenge Batson essentially ends or does end. Of course, there are post-trial motion practice that can occur. So the relevant time for this to be addressed, which the defense counsel was aware of, and that's why she strived to speak to that issue in a separate fair cross-section issue when it was still relevant for the trial court's decision. So I don't think that the defense counsel was seeking to sort of put a marker to be able to return to it, because that was the point of no return for the judge.
Well, but she did say at some point she's going to want to reserve. I just wonder if that's a source of some confusion for the judge, or what we're supposed to do with that potential.
Well, Mr. Chief Justice, I think if you see sort of as the colloquy goes down the page with, as you pointed to, it's clear in the record 3 times. Then the judge turns to reiterating his ruling, which again is merely a step 2 ruling as to race-neutral findings. And he says, so there is no Batson violation, drawing a line under the Batson colloquy at that point, and then shifting to the other issues, meaning that fair cross-section challenge I spoke of.
Could we interpret at some point from the defense counsel as an indication that she was preparing or prepared to make the showing, and she was asking the court for the opportunity to do so?
Justice Jackson, yes, I think that is the fair reading and an unmistakable reading of this record.
It does indicate that she was suggesting that she would like to do something. It wasn't as though she felt as though the batson objection was already, or at least her arguments were perfected. And it sounds to me from the transcript that the trial court was cutting her off, was not giving her a chance.
Yes,
Was maybe mistakenly saying.
So
that it
she
had
made
already
a
been
Batson
done.
claim or she
yes,
didn't?
Justice Jackson, if I could pick up on that last point, I think
It sounds like she
the
tried
cold record
to,
here,
and the
it is the cold
judge
record we're working
shut her
with,
down,
of
said
course,
it's already preserved for
indicates
appeal.
that if you look at
And now they're arguing whether it was
page
actually
168 in the JA
argued.
in terms of that initial call.
Interesting.
The Batson challenge is raised, and then Miller L is invoked. The judge is sort of reflecting a disorientation to what the Batson inquiry holds, which is 3 steps. He is speaking to the race-neutral proffers that correctly are the second step, but he's unclear whether this goes to all of the stricken veneer members or just the black stricken veneer members on 168. And so you fast forward to the proffers that are put forward by the prosecutor, and you see in rapid fire within a page the finding race neutral, race neutral, race neutral, race neutral. Let's return to striking the jury, and the court instructs the defense to continue the peremptory strikes. And so at the first moment where there is an opportunity to speak to this, defense counsel returns to the issue and seeks to be heard on it. And as noted, is told 3 times in a row, it's clear in the record, and then a reiteration of the ruling.
I guess
After the point that Chief Justice raised, at some point the court responded, "You've already made it in the record. Some of the opinion it is in the record," and then the defense counsel says,
Kavanaugh.
"Well, I don't want to let the paneling go by without having those objections," and then the court says, "I think you've already made those, and they are clear in the record." For the reasons previously stated, the court finds the reasons were race neutral, right? So that it continues on. I guess how we read that confusion is critical to whether there's a waiver here or whether it was unreasonable to find a waiver here.
That's right, Justice Kavanaugh.
If everybody could just tap the screen, it helps a lot. Thank you so much.
Addresses the D2 considerations in the case, and there are legal implications as well in terms of the mishandling of this. But reading that record and determining whether this is a reasonable determination that this defense counsel on this transcript had forfeited or failed to rebut when her effort to be heard on the matter was clearly addressed. And so
Counsel, in the
Yes, Your Honor.
post-trial motion that was made here, the jury was impaneled right after the exchange the chief made, so there was no time to make a record there.
Yes.
In the post-trial motion that was made by petitioner's counsel, I believe she did raise a Batson challenge, and she did raise the pretext argument directly, didn't she?
Justice Sotomayor, that's right, and that's very salient because that is, on this record, the first opportunity meaningfully to speak to the pretext question and comparison issue, which
Once the judge decided to panel the jury, the only time really to raise it again was on post-trial motions.
That's correct, Your Honor.
And she did. She said the reasons were pretext given, I don't have the exact language, or maybe you have it memorized, but given the voir dire was similar, they gave answers similar to the general public.
Poor Dyer,
to the other
goddammit.
people in the pool, correct?
Yes, Justice Sotomayor, and that's drawing from questionnaire responses because there was no voir dire to speak of the stricken individuals here.
Counsel, can I ask you how you think that the voir dire or the interchange
Barrett.
between counsel and the judge should have gone? One thing I find challenging in reading the transcript, it doesn't record pauses, right? It doesn't record seconds. And so if we had a transcript here where the judge said, "Sit down, counsel, I don't want to hear anything more from you," that would be a lot clearer, right? I mean, but we're in D2, so, the state's getting a lot of deference here. What do you think the judge should have done?
Justice Barrett, what we see commonplace in our courts is the court turning to the defense and offering the floor in some fashion. agreed, we don't have sort of an audio recording. We can't sense whether there's a pause here. But I think the context is really important. And this is a jury selection process with a voir dire that took about 3 hours. To put it in context, the Miller L. case, obviously it's really important here.
But you're not really answering my question. When she raised the objection, when she said she wanted to preserve it for the record, all she had done at this point, I mean, you're right, there are 3 steps, but so she raised the Batson objection, the prosecutor advanced the race-neutral reason, and she had the opportunity to impeach that reason, essentially, right?
Respectfully, no, Your Honor.
Well, let's see. That would be the 3rd step. What you're saying is that the judge cut her off before she reached that step, correct?
Yes, Your Honor.
I mean, I understood the fair cross-section point to be part of her effort to impeach, not just a distinct argument. Am I understanding that wrong?
Justice Barrett, I'll point you to JA 161 through 163, where there is a submission of this fair cross-section argument.
So she wasn't making that point also in reference to the Batson
There's some overlap because of the general issue with the jury, but it's a discrete challenge. And that shows up in the appellee's brief and the ultimate decision.
Okay, so I guess here's my specific question. If you could tell me what you think the judge should have done, because she raises the objection. The prosecutor offers a race-neutral reason.
Right.
She does raise, I mean, she speaks up, so she's able to make this cross-section point, which goes to, you say, there's some overlap. Should the judge there have paused to, I mean, so is the idea here that the judge should have paused and said, do you have anything further to say to show that this was pretextual?
Justice Barrett, there's sort of 2 junctures here within 5-6 pages of the JA that are important. The first are after the race-neutral determinations are made, the court then immediately instructs the defense to start striking the jury with the panel that's in the box. So after that's done and before the veneer is dismissed, or as the veneer is dismissed, the defense attorney returns to the issue and seeks.
But did the defense attorney have an obligation to speak up, even at that other point, and at the first point you're describing, and say, this is why? I mean, usually we expect lawyers to assert their points, to assert their objections. So I'm just wondering.
Yeah, but you're not going to fight with
the
the judge either.
To stop and elicit a response, or is it the defense counsel's burden to, because the defendant bears the burden of proving the Batson challenge, right?
Yes, Justice Barrett. In a situation where you have 4 strikes that are being addressed in succession, and the court elects to deal with the step 2 all in a row, it would be reasonable and certainly kind of the only way to encounter what's transpiring in that back and forth between the prosecutor and the judge to expect that step 3 will occur after that.
But did defense counsel have an obligation to raise the point?
The court has an obligation to conduct step 3 in the first place. The burden of persuasion remains with the defense counsel throughout all this, but it also coexists with a parallel duty that the trial court has to make its determination. And critically—
So are you returning to the argument which was addressed, the Fifth Circuit got to this point, that you're saying that the trial court made—
What's up, Law?
Oh, I just said that's a good argument. Sorry, you didn't need to pause it.
I gotcha.
no determination about whether there was a Batson finding?
Yes, Justice Barrett, that's what this record reflects. Yeah.
Counsel, I think if you look at Perkett, Hernandez, and Shiner, they answer Justice Barrett's question in that the obligation is on the trial judge to make a finding on step 3, correct?
Yes.
And to clarify, though, I agree with that. Right. I was just talking about the argument about—
Yes, no. And my follow-up to that was, I think what you're saying, given the transcript, is I think the judge believed he only had to find a race-neutral reason, because he says that at the very beginning of this process. He says, all I have, at times, a lot of times on Batson, I just have the state give race-neutral, I'm assuming he meant race-neutral reasons, as to all. Right. And she says, I think the jurisprudence simply states the court must make a determination on the basis of all the relevant circumstances to racial discrimination. The judge then says, I'll have the state give race-neutral reasons. And after each race-neutral reason is given, he then asks for the next one, and the next one, and the next one. And I think your point is he never pauses to give her a chance to address pretext, correct?
Right, Justice Sotomayor.
Or for him to make the required third step finding.
This is an exchange between the prosecutor and the trial court for all four of the step 2 steps.
Mr. Perkovich, what happened here is certainly not a model to be followed in future cases. But I wonder if you would agree that in interpreting this transcript, we can take into account the way defense counsel generally behave in a situation like this.
Justice Alito, if you could clarify that question of defense counsel's general behavior.
Well, this is the most timid and reticent defense counsel that I have encountered. Any competent
That's fucking dog shit. No attorney
would
is going to sit there and fight with it. Well, maybe they will, but you're not going to just try to willingly fight with the judge.
69, juror number 30, the prosecutor is called upon to give his race-neutral reasons. He says she has mental problems, according to a police captain. They've had numerous calls to her house and said she obviously has mental problems. And then the court says that would be race neutral as to that juror, and nothing is said. I mean,
in case anybody was confused, I hate Alito. He is the judge I hate the most. Like everybody else, I'm pretty chill. Alito can suck it.
So forth and so on, to make clear that the point is driven across to the trial judge. I don't understand what happened here, unless, well, anyway, I don't understand it.
Well, Justice Alito, I think the fact that this is sort of a two-person conversation, very clearly from the record, and that these strikes were clustered, reflected what was going on in that courtroom with the judge just addressing the steps in succession. I think the reasonable expectation is that defense was going to be heard, and that third step just did not happen. Rather, the court instructed her to strike her panel, and she returned to this once there was that opportunity that we've already discussed.
Yeah, but I know, trial lawyers have to have a certain amount of toughness, and she had every opportunity. And the judge didn't handle this the way it should have been handled. Yes. The judge should have said, okay, that's your reason, defense counsel, what do you have to say?
What was Alito's history before he joined law? Was he a prosecutor?
He's a solicitor general.
Point, and she didn't. It's not a case
I bet he was fond of fighting with judges.
Shut up, sit down, I'm going to hold you in contempt if you say anything more.
Justice Alito didn't get to that kind of pitch, certainly. However, the way this rush process occurred throughout the whole morning, culminating in the strikes, as I was starting to answer Justice Barrett, in context, the Miller L. voir dire took 5 weeks with a veneer that was 108 people as opposed to 96. So the rush nature of this, I think, informs how we make sense of this record. Another example of how rushed this was, because I think the judge was very sensitive to the sequestered jury's hardship. The liability phase ended a day earlier than expected, and afterward, counsel sought to have a continuance of a day because their single expert was subpoenaed in Texas. The judge denied that and forced counsel to proceed without their single witness.
I appreciate
this is all kind of dog shit.
And I understand this was not a model by anybody's stretch of imagination. But I didn't see where the defense counsel even mentioned the word pretext to the court anywhere in the transcript until after trial. Right. And given that
was the first opportunity.
Could somebody read this as saying, I don't have a pretext argument? I mean, we're on Ms.
Didn't he do defense work? Isn't that where Gorsuch came from?
Did she waive?
I don't
We're asking
think so.
whether the Mississippi Supreme
I thought he
Court
did
could
for some reason.
any
I don't know who
reasonable
I'm
jurist
thinking of.
could reasonably conclude that she waived the argument by not mentioning even the word. How do I help me with that?
There's a fair amount to unpack there, Justice Gorsuch. I'll try with the waiver question as sort of the end of this process. So before that is a finding, determination from the Supreme Court that there was a failure to rebut. And again, the effort is to be heard. The response from the court is, this is clear in the record, and then the lines drawn under Batson, and a shift is to the other issues. So the moment of truth for that was then, and as Justice Sotomayor pointed out, in the motion for new trial, that was the first sort of opportunity in terms of the basic procedure here to speak to that, which was done. Now, the D2 point is critical here, but also there's a D1 implication in this breakdown. And
well, help me with the D2, because that's what I'm struggling with at the moment. We have to decide whether the Mississippi Supreme Court made an unreasonable determination of fact. The determination of fact here is that she waived, or really more accurately forfeited. Yeah, it's her burden. We all agree on that, to raise pretext. She didn't raise pretext at all.
Well, Justice Gorsuch, if I may, so there is a burden of persuasion that sticks with the challenger, the opponent of the strike, and that's the defendant. There's also a duty that the court has, and that's first and foremost here.
I appreciate that.
And that duty is twofold, and that is to make a determination, irrespective of what's pressed by the advocate. And so there is a parallel sort of decoupling of it. That is really important here.
You could find no Batson violation if there's no pretext argument made, right?
Respectfully, no. Actually, the cases are quite clear.
Not if you don't give them a chance to make the fucking argument.
Sorry, the defense lawyer says, I don't have a pretext argument, Your Honor.
Well, that would be...
Then there's no finding required on pretext, right?
No, Your Honor. Actually,
there's no Batson violation, wouldn't you?
The burden of persuasion is with the opponent of the strike, clearly. And if the strike effectively expressly waives in that scenario, the court still has...
We have step one. Mm-hmm. Step two comes, the government's lawyer comes up with race-neutral reasons. Step three, suppose the defense lawyer says, I have no pretext argument, Your Honor.
Mm-hmm. Since the inquiry is made to step three, the trial court still has a duty.
Sure, to say no Batson violation.
Isn't the duty to look at the totality of the circumstances to determine whether or not the defendant has carried their ultimate burden of establishing discrimination? So it may be that with respect to that particular aspect of the back and forth, the defense counsel doesn't have an argument, or they say, I don't have an argument. But that, I think, is not the sum total of the court's obligation to rule on the Batson objection. The defense counsel didn't withdraw the Batson objection. Right. They just didn't make any argument with respect to pretext.
To be clear, I appreciate all of that. And I appreciate that the court has to make a determination. But the court here did make a Batson determination. He said, I find no violation. Now, maybe that's wrong, okay? Well, and I acknowledge it. It's a muddled record, but he didn't say, I find no Batson violation at the end of it. Now, well, maybe that's insufficient, but that's not what's before us. What's before us is was there waiver. Well, and help me with the D2 thing. I really want.
This is Gorsuch, Kiki.
I'm trying, Justice Gorsuch. But the key thing here is that his understanding from this record is of two steps. In other words, the equation is race neutral equals no Batson violation. It completely elides the duty he has to do two things, right? Once the case shifts to step three, the court has to afford an opportunity for the ultimate burden of persuasion to be met and make a determination, whatever is said, in pressing that burden of persuasion. Those things exist in parallel because the Equal Protection Clause is implicated here, because there are concerns that are greater than the defendant's, the stricken veneer member, the public's interest. And so all of that was jettisoned here. And I think it's simply because he was unaware of it, at least in this trial.
Thank you.
Thank you, counsel. Justice Thomas, anything further?
Justice Gorsuch asked you what would happen happen if the defense counsel said, I have no pretext, no refutation, no argument on pretext? And you said that there was more that the court was required to do in making the determination. What exactly is that? What do you mean by that?
I like
Your
this
Honor,
question
it's
for clarity.
incumbent on the trial court to assess what is before the court.
So what is before the court? You've got the initial assertion, you've got the race neutral from the prosecutor, and you have a defense counsel who says, I have nothing. So what else is there?
Justice Thomas, you have a prosecutor who failed to question on the reasons that he put forward as his proffers for these strikes.
Were those challenged by the defense counsel as pretextual?
As we've discussed, Justice Thomas, she did not speak to it after the Step 2 proffers, and that's one of the failings in this record. There was not an opportunity after the Step 2 proffers were made and before the Batson challenges were overruled to speak to that.
So you used Miller L., which brings back a lot of bad memories.
Sorry.
I'm going to pause real quick. So essentially what I'm getting here is like they make the Batson claim and the judge, it's ask the prosecutor, like, what are your reasons? Like why this, isn't this? And they're like, these are, my 3, 5, 10, 20 reasons, but they didn't give the defense a way to probe it. Is that what I'm understanding here, Law?
Yeah, so for a Batson challenge, you have to first make the challenge, and then the prosecution has to be able to give a neutral reasoning as to, well, no, that wasn't because of race, it was because of this or this. And then the defense, or the person making the challenge, it could be the state or the defense, 99.9% of the time it's the defense, says that has to offer some sort of reasoning why they believe that it's purposeful discrimination. And from what it sounds like in the record is that last part wasn't talked about. And
Yeah.
It's not clear whether it wasn't talked about because of the judge shutting it down or because of the attorney neglecting to make the argument. I'm more inclined to believe this is the good old boys in the South, and those judges think that they're little kings over their courtrooms. This was also a public defender who has to work with this judge every single day. So this whole Alito-esque, why didn't you pound the table? And that's just not how it works with public defenders, because you got to work with these judges every day. Doesn't mean that you're not being as forceful, but you can't afford the theatrics that might help produce, the kind of, movie scene scenario that Alito's looking for in this. And, private attorneys can afford to piss off the judges a whole lot more because they might be, before that judge once a year, once every 2 years or 3 years, versus somebody who has 10 cases before them a day. So I think the expectation there is a little bit unreasonable. Not that the outcome ever is any different, but I think the most compelling argument here is that there's no evidence in the record that the judge permitted that argument, and that's his obligation. The judge's obligation is to make sure that those three things are satisfied, and Gorsuch seems to be putting it on, well, absent of this being explored, we never know that it was actually discussed.
Yeah, I just wanted to make sure I was fully understanding this, because they're getting into the little detailed parts of the steps, and I'm like, okay, let me make sure I'm understanding this overall argument. The defense is coming in and saying, hey, you excluded this juror for racist reasons. The prosecution is answering with, well, no, I didn't. This is why. And instead of going back and to the defense, and the defense saying, oh no, I don't think so, that's not what happened. The judge was just like, nah, you're good. And then they let it proceed. So yeah, thank you for clarifying that, Law. I appreciate you.
Is implicated in that.
Yeah, okay,
but others.
I understand all that. Did defense counsel have the opportunity to question these witnesses? I mean, these jurors?
Yes, Your Honor.
On the voir dire. So the defense counsel could say, well, look, he's been very, he's happy to have these white jurors who have similar records. Then the judge has to make a finding. But if the defense counsel doesn't say anything,
Justice Alito,
what is the judge supposed to do?
Justice Alito, my response to your last question was there was questioning during the group voir dire. There was no questioning at that point after the proffers were made. And again, very legitimate concern in principle, implications in the criminal legal system. However, if that's a sincere concern, there's going to be questioning about it. And I think if we look at Miller L., there's a classic example of why, and that is with the field strike. In Miller L.,
well,
you have somebody.
I understand, but your argument is that even in the example that I gave you, where the judge says, "Defense counsel, do you have anything to say about this?" and defense counsel says, "No, nothing to say," that is not that there could still be a violation.
No, I'm conceding that, Your Honor.
So then the question is, how do we interpret this record? Suppose that the judge doesn't actually say that, which the judge should, but suppose defense counsel, as Justice Barrett was hypothesizing, could happen in some case. Defense counsel wouldn't, and nothing is said, or there's
imagine thinking that an attorney should demand something of a judge. That's crazy shit.
Then that's a different
in the
record
fucking
from
South.
what we have. To return to the sort of these legitimate.
Never have I ever, and I'm just a paralegal, but never have I ever seen an attorney be like, "No, mother," at least not when I've ever had to go
denoting a sham. In fact, that's language in Miller L. and Snyder as well. And so, it's not that that's not in principle, legitimate reason. It's that it's not explored, because often when it is explored, what comes to light in that process.
If I knew this case was going in the shitter, not even gonna lie, I would start fighting with Alito just for even proposing that.
For the prosecution, and they wouldn't use it as a reason.
Just start interrupting them and be like, "You didn't let me finish my."
Defense counsel standing up and saying, "Your Honor, I object. That's a pretext. The prosecutor has not applied that rule to white jurors."
Well,
all that was required.
Justice Alito, I'm referring to the duty that the court
has.
Oh,
yes, I did federal criminal. I'm just a paralegal, but law, my boss, he does a little bit of everything.
To be
He's a
aware
baddie.
of what has transpired in his courtroom and what has come forward in voir dire, what has not come forward in voir dire in terms of questioning, the irrelevance of the proffers to the case, the absence of record basis. You have proffers here, mental problems, drug problems. There's nothing in the record on that. And so the court just takes that on face value, and that's not the job. The job is to consider all the circumstances and to discredit proffers that are put forward without a basis in the record. None of that happened.
So if the prosecutor says, I'm striking this juror because she has mental problems,
I appreciate all the follows, the likes, and the taps, and the shares, and the gifts, and y'all are amazing.
You're just telling me the police captain says that she has mental problems. They've been to her house many times. We have to have the police captain come in here. Even though defense counsel hasn't said one word, we have to have the police captain come here and question, or the officers who made the visits to the house. Is that what you're saying?
Justice Alito, those officers were in the courtroom under subpoena first. So, and again, I return to the fact that—
I'm just trying to understand. I don't want to prolong this. I'm just trying to understand what you think had to happen here. And your first answer was, if defense
they had
counsel
to
says
give
nothing,
defense an ability to make their challenge. That's what had to happen here.
The judge can simply say, "Okay, fine. I find that it's not a racially based challenge."
Justice Alito, as I've been trying to advance, there still is this duty for the court to consider all the circumstances bearing on racial animosity.
I feel you, Kelly.
And to make an assessment, whatever is advanced here. And obviously our cardinal sort of point here is that on this record, you have a defense counsel—
Alito's the worst. TikTok, don't ban me.
And the response from the court is, your case is in the record, and I'm going to reiterate my ruling.
I understand that.
Okay.
Justice Sotomayor?
Going back to that point, what's clear from the record here is as soon as he exercises a challenge against the woman with mental problems, the prosecutor then says, the next juror, juror number 3, she was juror number 2, and the court interrupts and says, that would be a race-neutral, again, reason as to that juror, meaning the mental juror. And the prosecutor immediately goes to S3. So there's no pause there.
None.
No pause between the 4 jurors and the race-neutral reasons. So there's no chance for the defense attorney to say anything, correct?
That's right.
Now, you get to juror number 4, the same pattern. Juror number 5. And then he gets to the last juror that's being discussed and race-neutral reasons, and immediately says to her, you have to start with jury selection.
That's right.
Again, there's no pause to say, do you have a response? When you're saying to Justice Alito that defense counsel should have asked questions of the jurors, she was never given an opportunity, you're saying, because the prosecutor never did any voir dire of these jurors.
Right.
So she had no way of knowing that any of these things bothered the prosecutor, correct?
That's right, Justice Sotomayor. As I pointed out earlier, the proffers were not questioned. So the only questioning that this prosecutor did of consequence was to do death qualification, which resulted in the decimation of the black veneer. So you have a concentration of questioning, JA 95 to 104, where in rapid succession he's questioning, I think, 37 different veneer members, 28 of them black, to elicit responses that lead to cause strikes. That's the level of questioning that's going on in this record. There's essentially no individual voir dire at all. There are 6 individuals who are questioned near the end of voir dire, and it transpires on a single
defense counsel
page.
can't be faulted for not knowing what the prosecutor was worried about.
Exactly.
And asking questions. Now, going to the question that
Hey, Law, just for a second, can you briefly speak to jury selection, just kind of basics for people? I have people asking questions, and I don't want to not nail this for them.
Yeah, sorry, I wasn't looking at the screen. Does
you're
the defense
good.
attorney have the burden of proof during the selection, or is it equal burden? So if you're whoever raises the Batson challenge has to establish the reasoning, and then the court has to rule on it. So I have a county one of the counties that I work in that is, 85% WT, and the juries are almost exclusively all WT, and the prosecutors will routinely use their preemptory strikes on persons of color, if particularly when I have a client that's a person of color. And it's not enough to just say that, well, that was because they were a person of color. I have to come up with some sort of argument as to that being their only reason. And that gets difficult because the burden is then on me to try to basically accuse the prosecutors of that. And then the prosecutors have to say, well, no, I did it because of this. So each side gets a certain number of preemptory strikes, which you could strike for any reason except for race or protected class. And that's where the Batson challenges come in, is if a prosecutor or defense attorney uses one of their preemptory strikes and the only reason is because of their race or they're a woman or whatever the case may be, then the burden shifts to the other side to establish why that's not the case. And generally just saying that, they didn't ask them any questions probably isn't good enough. But that seems to be what happened here. And what amplifies this is multiple jurors that were persons of color used their preemptory strikes that weren't asked any voir dire questions, or voir dire for you Texans.
God dang
weren't
right.
asked any questions in order to establish any sort of reasoning why a preemptory strike would be used. So we're kind of in this gray area where the prosecutor really has no reason to exclude these people that could have been explored because they didn't ask them any questions. But then how do you prove that the only reason that they did that is because of their race? You're kind of in this catch-22.
So, and just for clarity, in this particular case, when I was reading about it, about 40% of the population in this area is Black. all the jurors except for one were white jurors. So it's something interesting to keep in mind as we're hearing this right now. But thank you, Law, for clarifying that. You did a much better job than I could have, because I would have butchered that. So I appreciate you.
Violation. And let's turn to the other issues, the fair cross-section issue. So she's striving to be heard, and then ultimately she's reasonably relying on the court saying it's in the record. And this is in a context where she raises Miller L., which had been decided about 6 months before this trial, wherein clearly the ability to press a case on appellate review was the letter of the day. So she's relying on what the trial court is saying, that this issue's over, and the trial is moving forward, and opening argument is going to happen in a moment.
What do you think about the Judge Mills' comment, perhaps Pitchford's counsel should have been more assertive?
I think that
it was an unaliving penalty case, Kiki. I'm not sure, but I'm going to guess it's at least 12.
Where there's more hurly-burly, let's say, and elbowing. But the point is that she timely raised the objection. That's her duty. There's not a continuing objection requirement. There aren't authorities supporting that. And she sought to be heard before it was too late. And then at the next moment, as Justice Sotomayor pointed out, where she could address these issues in the motion for new trial, that was done. Adequately so. It was fit for purpose in terms of the motion for new trial. So if the judge was actually concerned about these issues, he had an opportunity to take the case back before it was up on appeal.
Thank you.
Justice Barrett?
I have a few clarifying questions, excuse me, about your position. One, are you asking us to revisit Ford insofar as it said that a state has the flexibility to adopt procedural rules for the assertion of batson objections?
Justice Barrett, certainly no. That I would point out is dicta, though. Ford was a case where...
So you are asking us to say something different? Or do you agree that states have the right to come up with rules of forfeiture even for batson objections?
Justice Barrett, certainly the implementation's left to the states. And as we've seen in Johnson versus California, where there was a step one issue that California had, there can be problems in that. And what we have here with respect to step three and this particular ruling on waiver and the failure to rebut being the predicate for that is an example of faulty implementation.
But you're not challenging the state's ability to set forfeiture rules and to say that if you don't make a timely objection, you forfeited it. I'm asking you as a general rule. I understand your argument that she wasn't given a fair opportunity here. I'm not asking you about that right now. I'm just saying you don't disagree, do you, with the fundamental proposition that a state can establish procedural rules requiring the timely assertion of batson objections?
Justice Barrett, the last formulation you gave, I would agree with, certainly.
You would agree with that? Great.
The very last formulation, though.
Okay, thanks. The other question I have, it's a little bit difficult to tell at some points in your brief. I read your brief to maybe be taking the position that an appellate court has an obligation to conduct the batson analysis, even if it wasn't made below. So, for example, that the Mississippi Supreme Court here actually had a duty to conduct the comparative juror analysis?
Well, I think the first point here is that the understanding of its own law for batson was that it could not, right? And that it was unable to consider arguments pressed for the first time on appeal, especially in a context where the first opportunity to do that was on appeal. That's a problem. And so it's that fundamental misunderstanding of this court's law in that basic gateway role at the outset of the appeal that is the first problem.
So what is your position? That an appellate court has the discretion and should understand itself to have the discretion to consider it for the first time on appeal, but not an obligation to do it?
Justice Barrett, this court's holdings have relied repeatedly on comparison that's been pressed in the first place on appeal.
But is it an obligation, or do you just have the discretion? Just pick one.
Justice Barrett, I'll pick discretion with the caveat, though, that the language of this court is a must.
Yes, I will be doing birthright
So is it
citizenship
obligation or
tomorrow.
discretion? Must sounds like obligation. It's just not how I read our precedents.
Right.
So you're asking for us to take those precedents if there's any ambiguity in the precedents, or to take them a step farther and to say there's an obligation?
I think that the precedents have to be surmised from what the court is doing and how it's getting to the results in terms of the holding for clearly established law. And what the court has done routinely is take argument, comparative analysis that's really not viable in most trial settings and hear that on appeal in the first instance because of the concerns I was speaking to earlier.
Okay. So do you think we have what we need if we were to conduct that comparative analysis now to find a Batson violation now?
I think, unfortunately, that was the ball game for the state Supreme Court. And they elected not to do that. They had, in that fork in the road, they could have taken what was submitted on appeal and make a merits decision,
So
or
there was sufficient
remand it.
evidence in the record on the comparative juror point. The comparative juror analysis, it's your position that the record is there, and the Mississippi Supreme Court could have, based on the record before it, or that we could now say that there was a Batson violation based on.
So for clarity here, Law, they're asking for, the case to be retried because this is an unaliving penalty case. The court violating sort of this procedure for the Batson violation, is that a reason for the case to be retried, in your opinion?
Yes, if the judge did not appropriately explore a Batson challenge, then that means you didn't get a fair jury. And if you didn't get a fair jury, the only remedy for that is a retrial. I imagine that, it's kind of split here. If it did get overturned, the conviction would be overturned, and then it would be sent back down to the trial court for a new trial. The judge might try, or the justices might try to split the baby a little bit and say the appellate court failed to appropriately analyze whether the Batson challenge was accurately done, give them some guidance, and then send it back to the Court of Appeals to assess whether or not, the requirements of Batson were met.
I gotcha. Thank you so much.
If we're in a world that Justice Thomas posits, if the defense counsel, when we get to step 3, the trial court says, counsel, and defense counsel says, Your Honor, I have no argument on pretext. Well, first of all, you would, I think, expect the court to say, so are you withdrawing your Batson objection, counsel? Justice Kavanaugh says, well, that's sort of implicit, but I think the court, because it has a duty to resolve the objection, has to be clear about whether this thing is still on the
right
table
there, I believe.
Counsel affirmatively
absolutely. She's
says,
got
I
more
don't have
criminal
any
law
pretext
experience than all the other justices
So right there,
combined.
we have a problem with the court not clarifying whether this
banger.
objection is still live in the world of even asking. But in the world of not asking, not asking the defense counsel whether there's any pretext evidence, you would still have the court have to resolve the objection, right? Yes. You would expect the court to say something like, hearing no evidence or argument related to pretext and seeing no basis in this record for determining that the prosecutor's race-neutral reasons were pretextual, I find that there is no race discrimination or whatnot, right? The court has to make a finding that indicates that it's actually resolving the objection
this is
on
Justice
the basis
Jackson.
of all of the
She's
evidence
amazing.
presented after all of the steps. And it seems to me that there's kind of a problem here. The lack of clarity is a problem for the court because it suggests that the court
because the lack of clarity muddies the waters, but it also allows them to go the other way.
Objection.
Well, they didn't say you couldn't.
What you're trying to say?
Yes, they fucking did.
The number one job of the judge is to preserve the
Justice
record.
Jackson.
So any faults in the record fall on the judge.
Counsel has a duty to press the case, and the ultimate
Thank you, Law.
duty, or burden of persuasion. But that's simultaneous with the duty that by the time this gets to step 3 in the burden framework, it remains with the court to do the things that you've outlined.
And the court can say there's not evidence that there's discrimination here, you haven't presented anything, et cetera. But here we have a court that's seeming to keep the defendant from making her presentation. So I don't understand how the court could have fulfilled its obligation to look at all the evidence if it has prevented, essentially, one party from presenting. Let me just ask you another final question. I see this also as possibly a very short opinion. When we look at what Mississippi's Supreme Court said, it would go something like, Pitchford's trial counsel made a Batson objection and re-raised it multiple times. Each time, the trial judge reassured her that it was preserved. Nevertheless, Mississippi Supreme Court said it was waived. That's unreasonable. The end. What would be wrong with that?
Not anything I can think of. I mean, we could say more because with respect to D2, obviously, there is a breakdown in that fact determination that becomes a waiver under the Mississippi rule. With respect to D1, another way to look at this is a case that I don't think this court has seen where it just sort of falls off the ledge at step 2. And so that's a D1 failing categorically. There's just an absence of that step being taken for the reasons you've outlined.
Thank you.
Amen.
Thank you, counsel. Mr. Stewart?
Mr. Chief Justice, and may it please the court. In Flowers versus Mississippi, this court faced an extraordinary case and ruled against the state. This case is also extraordinary, but in a very different way that requires a very different result. Start with the facts in D2. Petitioner claims that the state Supreme Court was objectively unreasonable in finding that he waived his pretext arguments. As Petitioner once admitted, that is wrong. Years ago, Petitioner declared that he failed to, quote, properly challenge, litigate, and preserve, end quote, his pretext arguments. Petitioner also now claims that the trial judge thwarted his efforts to argue pretext. Years ago, he said the opposite. He declared that he, quote, made no attempt to rebut or otherwise offer argument or evidence, end quote, on pretext. In short, Petitioner once
fuck my life. The Solicitor General is participating in this argument too. I fucking hate it here.
That is extraordinary.
Bullshit.
Now take the law. In Ford versus Georgia, this court ruled that lower courts can adopt timely preservation rules to implement Batson. Many courts have done that and adopted a waiver rule like the one applied here. Petitioner ignores Ford versus Georgia. He never cites it once. And he asks his court to declare that a rule adopted by most federal courts of appeals is not just wrong,
It's like
but objectively
the lawyer
unreasonable.
wants you to actually follow rules in court. It's fucking
Petitioner
crazy.
also claims that
The
state
Trump
trial
admin
judge
hates
failed to
that though, so
conduct
this makes
step 3
sense.
of Batson. That was the core of his presentation this morning.
Pause it real quick.
That defies what the trial judge said, and it once again defies what Petitioner has said.
So what they're doing is the public defender made an affidavit in response to an ineffective assistance of counsel claim brought up on appeals, which everybody should do. I tell my clients that get guilty verdicts, you're not hurting my feelings. If somebody looks at this and says I should have done something differently, I will send a letter and say, yep, I didn't do that and I should have done that differently. I'm not immune from making mistakes. And also, like, sometimes I have a strategy in mind and that strategy didn't play out and a different strategy might have played out. If they want to say that's ineffective assistance, by all means, they're entitled to that and absolutely willing to do that. Ineffective assistance of counsel doesn't hurt your bar card. The standard to receive sanctions for that is significantly higher. You have to be like falling asleep at the bench in order to have sanctions on that. But on appeal is that there was a clear error made by the attorney. Something like that. And so what it looks like this attorney did was submit a letter and said, I didn't make any of those arguments. They didn't say I was given the opportunity to make those arguments and it was denied. They just simply stated the fact that I didn't make those arguments. And what the record seems to show is she never had the opportunity to do that. So both of those things can be true at the same time, yet the attorney for the state here is seemingly arguing that, well, that's a concession that she never actually, that she didn't do her job. And the thing is, you tend to, when you're trying to help your client out on an appeal, you're going to put the facts in the light most favorable to their appeal. That's just what you're going to do. And this is very carefully worded to say that, not to say that that the judge denied me that opportunity because that's not what's before the court on that particular challenge. It's that I never made those arguments, and it very well could be the reason why she never made those arguments because she wasn't given the opportunity.
Thank you, Law.
Didn't the court say it was preserved? I mean, she was obviously saying, I would like to make my record.
I want
with
Jackson to
respect
get
the
in there.
Batson observations. So the Chief Justice points out, she says, at some point, I would like to do that. So you just articulated the kind of thing you would have expected her to say, and I'm trying to figure out when she was supposed to be, or given, when she was supposed to have that opportunity.
Sure. At page 169, at page 170, at 175, 176, she could have said that anywhere there, Your Honor.
You mean when the objections were happening?
Oh, yes, of
Did
course.
she have to? Could she have done it after all of those objections were lodged?
Sure. She had to do something.
But when she went to do that, when she tried to do that, she said, at some point, I'd like to do that, and the court said, you've already done it. So whose mistake is that?
He did not say you've already done that, Justice Jackson. What he said was you preserved your Batson objection.
He said, I think you've already made those, and they're clear in the record. And that's after this, another sentence where she adds, she doesn't just say at some point. She then says, I don't want to let the paneling of the jury go by without having those objections. And the court says, I think you already made those, and they are clear in the record. For the reasons previously stated, the court finds there to be all the reasons were race neutral as to members that were struck by the district attorney's office, and so the court finds there to be no Batson violation. Right? She's trying to make the objections right there, and he says you already made them, and there's no Batson violation, and he makes a legal error in the course of that by saying because they're race neutral, there's no Batson
Okay, so I
violation,
think I'm feeling good on Kavanaugh on this. I'm not going to lie.
would acknowledge.
I think, so two responses on that.
So right there, she's trying, I think. I mean, she could have been more assertive. Judge Mills, so your opening was forceful. Judge Mills is a very experienced district judge. He'd been a former Mississippi Supreme Court justice. He knows what he's doing. He read the record entirely differently.
Apparently not.
And he pointed to this part right here where she's trying, I think, we weren't there, we don't have an audio recording, to make the objections, and the court says you already made those, they're clear, and the court finds there to be no Batson violation. I don't know. At that point, she could have said, well, you're wrong, Judge, I get that, and Justice Alito has good points on that, but it seems pretty clear at that point.
Well, Your Honor, I mean, she preserved her objection. She didn't preserve the pretext arguments, which are different than making a prima facie case or the objection itself. Comparative juror arguments are very different in response to the state's reasons than simply making a prima facie case. And she didn't raise those.
You don't think at that moment right there she's not prepared to do that?
I mean, not at all, Your Honor. I mean, the very next page, on page 170.
He says there's no Batson violation per se. I don't know. I mean, that's where Judge Mills says perhaps she could have been more assertive. And I take that point, and that's why this is hard.
Well, I think, and this would get back to, I think, you think framed it correctly earlier, Justice Kavanaugh, where you said, look, is it objectively unreasonable? Is D2 met? And I think the ways we know that are a number of them. First of all, Ms. Steiner speaks only from page 158 to 176 of the transcript. During that time, she at least 5 times inserts arguments or objections without any prompting by the trial court. There's this talk about, are there pauses in the trial court? There are no indication of pauses in here, yet 5 separate times, in addition to all the arguments she makes, she inserts herself. I mean, that was the Batson objection. There's no indication that the judge paused, looked at her, and said, will you make a Batson objection? She inserted that. She inserted the bench conference. I'd close the point by noting at page 176 that the judge then did allow her to state the composition of the jury, her assertions about the composition of a county, and so she had an opportunity to add more, and that's all she added was bare numbers. Then we look at the post-trial motion. Even when she had days and days, all she came up with, and this was belatedly, it was the amended motion for a new trial, belatedly comes up with one sentence that points the judge to nothing about these comparisons.
Well, that's in the course of... Go ahead.
I mean, I think you've made the point that she didn't do very well, that she could have done a lot better than she did. But that's really not the question before us. The question is whether she's waived her objection. And 3 times she's told by the court that the objection has been preserved. So you're right, General. She should have said a lot more stuff. She should have been more assertive. But the only question before us is, did she waive her objection when 3 times she's told by the court, your objection is in the record. I hear you.
And this is critical, Justice Kagan. The Mississippi Supreme Court did not hold that her objection was waived. It held that her pretext arguments were waived. It upheld the
That's
finding
slicing the bologna very thin.
It's not just
I'm
Justice
sorry.
Kagan.
Not the
General
baloney.
Stewart,
My apologies.
here
Justice
we
Kagan.
are, after the prosecutor has done all his, here's my race-neutral reason, here's my race-neutral reason, and then the defense counsel
I
says,
love Kagan.
I'm not persuaded. I need to say something about this. I still have an objection. Well, at that point, of course she's objecting to the ultimate finding.
The
I mean, she's
This is after the prosecutor has given all his race-neutral reasons, and she's still objecting. So what could she be objecting to at that point?
I agree.
She must be objecting to the fact that either the race-neutral reasons aren't credible, or they're pretextual. That's what she's objecting to. But there's no other way to read the context of this colloquy without saying that at that point she's objecting. She's saying what the prosecutor gave you wasn't enough.
I agree that she is maintaining her Batson objection, Your Honor. I don't agree about the comparative juror pretext arguments that she made no suggestion of making despite many opportunities to do.
I think you're arguing this on the merits. I think you're saying she didn't say enough to allow the court to find for her. But that's not the question before us. The question before us is whether the state Supreme Court was right when it said she waived her argument. She might not have presented a good argument, but she didn't waive her argument.
Yes.
And respectfully, Justice Kagan, the Mississippi Supreme Court didn't say she waived the argument writ large. It said she waived the pretext arguments that she never presented to the trial judge. And that's critically different. Justice Graves, in dissent, my friend in his federal habeas petition, agreed that the Mississippi Supreme Court resolved the claim on the merits. It held that the Batson pretext arguments, the comparative juror arguments that she had never made to the trial judge, that's what she waived.
Well,
that's what she failed.
Can I just follow up on Justice Kagan's questions? After the prosecutor gives the asserted race-neutral reasons, what else could she be objecting to than that those were pretextual?
I mean, I think. I think she's saying, like, I believe that I've made my case. I mean,
No. Answer my question. After the prosecutor has given the asserted race-neutral reasons, what else could she be objecting to other than that they were pretextual?
I mean, I think she's. Are you talking about page 175, Justice Kavanaugh?
Exactly.
Okay. I think there she's just making sure that her objection is preserved in the record.
What else? That's after the asserted. Just answer my question.
Kavanaugh is
After
not
the
having this
prosecutor's
shit
given
today,
the
and I'm here
asserted
for it.
race-neutral reasons, and she goes back to Batson. At that point, what else could she be objecting to other than that the asserted reasons were pretextual?
I mean, I think it's the ultimate conclusion the district judge reached, or pardon me, the trial judge reached, that they were race neutral in fact, and she hadn't shown discrimination. I mean, I think that's why I think she uses the word reserve, and I think she wants to make sure. I mean, that's the 175.
Roberts is going to be the decider in this.
And then that's the first sentence. The second sentence, I don't want
I'm
to
already
let the panel
narrowing
go
it.
by without having those objections, and then repeat myself. I think you've already made those, says the judge, and they were race neutral. Can I ask a separate, distinct question, just one question, which is, in the course of that
Thomas
paragraph,
Alito
the
and
court
Barrett, I
says,
think, are on the same page.
and this is now a D1
Robert's
question.
the only one I'm out on.
Okay. The court says, the trial court, all the reasons were race neutral as to members that were struck by the district attorney's office, and so the court finds there to be no Batson violation. Is that a legally correct analysis of Batson?
It is, in that it means that he is finding the reasons to be race neutral in fact.
But is that the end of the Batson analysis in your view?
I mean, if he's finding them to be the actual reasons, the race neutral reasons in fact, then yes.
If they're race neutral, is that the end of the Batson analysis?
If the question is just, are they facially race neutral, then that's step 2, Your Honor.
Right, and that's not the end of the Batson analysis, correct?
Whether there's a facial justification that's race neutral is not the end of the Batson inquiry.
Thank you.
What I'm suggesting.
Thank you.
But whether in the end they are race neutral is the question, right?
That's right, Your Honor.
And as to what she was objecting to, if she wasn't tacitly raising a pretext argument. What she said on 176 is, allow us to state into the record, there is one of 12 of 14 jurors are non-white, whereas this county is approximately, what, 40%. What she's saying is that the racial makeup of the jury that was selected was so starkly different from the racial makeup of the county that would be sufficient to find that there were Batson violations.
Right. That's right, Your Honor. And actually, in the cert petition at page 38, the petitioner emphasized this point as being part of the Batson presentation.
Counsel, I don't know how that could be. She starts her colloquy in that section by saying, I want, at some point, the defense is going to want to reserve both its Batson objection and a straight for 10th Amendment racial discrimination. That reference, I don't think it was on the 10th Amendment. I think what she meant was the earlier objection that they spent a lot of time in voir dire on the cross, whether the jury pool was a representative body, correct? There had been two
objections there, Your Honor.
All right, so she's talking about the the representation argument and the Batson argument. On the Batson argument, the court starts with that and says, you have already made it in the record, so I'm of the opinion it is in the record. She says, I don't want to let the paneling of the jury go by without having those objections and court things. I think you already made those, and they are clear in the record. For the reasons previously stated, he says, all the reasons were race neutral, blah, blah, blah. And then as to the other issue is the jury pool issue. I've already ruled, based on prior rulings from the United States Supreme Court and the state of Mississippi, that jury selection was appropriate. That the jury itself, the pool, was appropriate. And those are noted for the record. It is then when she starts talking about the jury pool as a whole, that as a whole, and not on the Batson question. So I'm not quite sure that you're fairly
She's saying you're dicking around and you're misrepresenting the argument she made, Kelly.
Let me cite you something that shows that it is a fair representation. It's page 38 of the cert petition. That's petitioner's filing, where he ties that very exchange to his preservation of his Batson claim.
But counsel, I think in fairness, Justice Kavanaugh asked you what more could she have done, or why wasn't she, responding to or trying to say that there's pretext when she was talking about the Batson question. You pointed to this 40% issue that she talks about, 12 of 14 jurors. But as Justice Sotomayor points out, that discussion was in reference to the
12
jury
of 14, sorry.
issue and not the Batson issue. So regardless of what was happening in the cert petition, I'm talking about what's going on in the trial record, in the discussion that they were having. It looks as though the court resolved the Batson question.
So we'll just take a step back here. You said 12 out of the 14 jurors. I'm sorry, I thought it was only one, but it's two. 12 out of the 14 jurors were white in a community that is 40% black.
But I think one of the persons of color was an alternate, so they weren't ultimately a juror that made the decision.
Yeah, so that's kind of what this sort of argument is coming back to. And like we're talking about, representation in a jury and things like that. And I agree that while, excluding a juror and then a defense making an argument that, 40% of the county's black and you did this just because, that's probably not a good argument, right? But it still doesn't satisfy what she was talking about, Kavanaugh's question, which is, what else could she have done? The prosecutor said, I didn't do it for X reason, and the judge didn't give this attorney a chance to do anything else. And I think that's kind of what it comes back to. I don't know, Law, did you have any thoughts?
No, I think that's good.
Okay.
Would you like to say more? I mean, she said the more that she wanted to say, and the key thing is even when she had that opportunity, she did not present the comparative juror arguments.
I don't think it helps to misrepresent what the record obviously shows. Let me ask you another question, because it seems as though the Mississippi Supreme Court is trying to have it both ways with respect to the significance of her arguments related to pretext. Is it your position that that her argument was so central that the failure to present it waives any obligation of the court to rule on whether the reasons that the state has given are race neutral and therefore there's no batson violation here? Because she didn't say anything about it, or as you interpret the record, that alleviates the court of any obligation to say. That's one thing that I think the Mississippi court is saying. But on the other hand, they also say it isn't necessary for the court to give her a chance. So either it's central, in which case the court had to give her a chance, or it's not central, in which case the court had to rule on it, I think, regardless. So which is it?
I'm not sure I'm completely following the question, Justice Jackson. What I would
How
say...
could you
What
not
is the
follow that
significance of
fucking
her
question?
argument related to pretext? Is it so necessary that without it, the court is relieved of any obligation to continue to look at the facts and to actually make a finding? Or is it not necessary, in which case it seems to me that the court needed to do that regardless of the fact that she didn't bring any argument about it?
Right. So I think if you get past step 2, the court has to make an ultimate finding on non-discrimination, but it does so in light of the parties' submissions. No precedent of this court requires the judge to consider matters, especially intricate comparative juror arguments, that are not presented to it. I mean, that's something this court, it's in light of the parties' submissions.
Justice Jackson.
I just wanted to, and your view is that if the court has to do its obligation in light of the parties' evidence, the court does not have the obligation to turn to her and say, what is your evidence about this? The court doesn't have to solicit the evidence from this party or give her an opportunity to present it.
Well, it doesn't have to affirmatively do that. There's every indication that in the trial, in the record here, and a reasonable person could certainly read the record to allow multiple opportunities to present that. There's nothing supporting the idea that the trial judge
Kelly,
offer, certainly nothing compelling that view of the record, Justice Jackson.
Thank you, counsel. Justice Thomas, anything further?
Yes,
Okay,
General,
hold on, real quick.
you were
I'm
about
sorry, I'm going to cut Clarence Thomas off. He should really read audiobooks instead of being on the Supreme Court. But regardless, did I just hear the state make the argument that they don't have to allow the defense to actually defend their position? Is that the argument I just heard, or am I high right now?
No, it kind of sounded like that.
Okay, I just want to clarify real quick, just to make sure. And just for clarity, Law, you would know that it's not how the Batson claim works, is it?
No, the specific obligation is that they have to proffer the evidence of the discrimination.
Okay, I just want to make sure everybody in our live is on the same page. Okay, because I couldn't just slide that past that, like they didn't just say what they just said. So, okay, thank you.
And the record can be read certainly either of two ways. That would be enough on clear error review, Anderson versus Bessemer City. It's certainly enough for the state under AEDPA. Thank you, Your Honor.
Justice Alito? Justice Sotomayor?
You seem to be suggesting that the only way that we could overturn the Mississippi or honor EPA is if the district court had said to her, sit down, counsel, you made your Batson challenge, period. Anything short of that, they couldn't err in finding a waiver.
I mean, given the entirety of this record, there's no
well,
other reason.
No. I'm saying your argument seems to be.
I love Sotomayor, but she talks so fucking slow. She's got to speed it up.
The trial court said, counsel, sit down, Batson's been preserved. I don't want to hear anymore. That's the only way that on EPA review we could say Mississippi made an unreasonable determination of fact.
I want to get to Jackson's what the fuck. I feel like she's going to be feeling me on
given
this.
Record, that you would
Where
need
have we
like
ever
that.
said that a waiver has to be that explicit.
Yes,
Don't we
Malibu. I had a
infer
big
it
problem with her
from
not
evidence?
retiring before
Well, I
Biden
mean,
left
even if that were true,
because she
Justice
should have.
Sotomayor, this gets back to
What?
what I was
Even
just
if it's true, an unreasonable doesn't mean that all interpretations of a record are correct. I'd like you to point me to one part of this record, one word by the court that says, do you have something more on race neutrality?
But that's exactly the point, Justice Sotomayor. She has none of that, and she has multiple indications that she would have.
No, the problem
she
is
It's
that
the
she was
judge's
never
job.
given an opportunity on this record.
That fucking
the way
part.
the record. Well, we can go. I'm not going to argue with you on this point.
May I
Record
respond
speaks
just briefly?
for
I think I could
itself.
say something helpful on this.
No,
Justice
no, no.
Sotomayor.
I was going to ask one last question. Okay.
She said, I don't want to hear your
on
shit.
the preservation issue, not on the preservation issue, on the
Oh, no, Kiki. Like, I don't doubt her
comparative
ability as a
jury
justice.
analysis on appeal.
She just drives me crazy.
The comparative jury analysis on appeal. In answer to Justice Barrett's question, appellate courts can
agreed,
do their
Victoria.
own comparative juror analysis, even if not preserved below, correct?
They can.
That's what happened in Miller, L., and Schneider. Do you believe the Mississippi Supreme Court says it cannot consider those arguments because of the waiver, or that it's choosing
Law, can you
not
watch
to
it for just a
consider?
second? I gotta run and take a
It's
break
saying
real
that
quick.
In general, it does not. It can exercise its discretion to do so. We
It
know that
could do so.
it could do so.
So is that a plain error standard? Because plain error is what federal courts use to review evidence that has not been an objection that has not been preserved below. It would be plain error, correct?
I mean, that's what has been said in the case. I mean, Flowers versus State 3, the Flowers case. I mean, what the court says was because the error in upholding the strike of Juror Pittman affects a substantial right, we apply the plain error rule to find a Batson violation occurred.
So
I mean,
Mississippi has a similar plain error rule. It has discretion to overlook a waiver, correct?
It has discretion.
So if the record is clear that there was a Batson violation, and we can argue about each individual juror, whether the record is clear or not. I want you to make an assumption. If the record is clear that there was a Batson violation, would the Mississippi court have erred in failing to conduct that review?
And the answer is no, certainly not under EDPA.
No, none under EDPA. It's a constitutional violation in a case where the court below did not make an actual Step 3 analysis. You're saying that it wouldn't have been error.
I mean, that's consistent with the waiver or forfeiture of constitutional objections generally, and with jury selection in particular.
We apply plain error.
And but state courts don't necessarily have to do that. They can do pure discretion. They can do different approaches. Nothing in this court's cases bar that, Justice Sotomayor. And I mean, I would just emphasize that this is a rule that has been embraced by most federal courts of appeals, and it's one that was surely reasonably applied
Yes,
here.
because we apply plain error.
Some do, some don't. And again,
You always have to apply plain error.
that's not
Plain error is required by the rules of federal procedure.
and
If an objection has not been preserved, the court has to determine whether the error was harmless,
and
or
I'm sorry, Justice.
whether the error was harmless.
This
May I
case
respond to
deals
that?
with
I'd
racism,
come back
jury
to Ford versus
selection,
Georgia, where the
and
court affirmed that
more
state courts
largely
can adopt these
Batson
timely
claims
rules.
in
Perforce, those
strikes
rules
on
are
a
going to
jury.
block some claims, perhaps even some meritorious claims. And given that signal, it was surely reasonable to adopt this rule, which ultimately vindicates and enforces Batson itself and makes for better Batson rulings as we do.
Thank you, counsel.
Justice Kagan?
General, I want to take you back to the conversation that you and I were having and that you were having with Justice Kavanaugh, which is just this question of waiver, because I do believe that given the Mississippi Supreme Court decision, that's the only question before us. The question is not whether this defense counsel put enough in the record to actually prevail on a Batson claim. The
Amen.
question is instead whether the Mississippi Supreme Court got it really wrong when it said that she had waived her argument that there was a Batson violation. And again, I'm just staring at this transcript, and I guess as to that question, I don't really see the ambiguity in this transcript, because this is coming after the fact of the prosecutor saying we had race-neutral reasons for all of them, and she says 3 times, I want to contest that, and the court says over and over, it's in the record, it's in the record, it's clear in the record. And when a court says that to you 3 times, I actually don't believe that it's like, I'm not going to say, what can you do? I think she could have done more. I think she could have said, Judge, really, I'm not moving on to anything else until I get this out. But on the other hand,
I don't think that would have worked out well for her,
ineffective
but
assistance
okay.
of counsel to make a different kind of choice, to say I don't want to antagonize this judge. If he's insisting on moving on, I better.
Law, real quick. If you told a judge, I'm refusing to move on from something, how well would that work out for you?
It definitely wouldn't work well in Minnesota. Sure as shit wouldn't work well in Mississippi. And at the end of the day, this is the judge that's trying your client's unaliving case. So the last thing that you want to do is have the judge be pissed at you for the entirety of your client's case.
Yeah, I just hate this premise. She could have done more. The judge dictates the tone, the record, everything in a case. And certainly, yeah, Victoria, I'm in Texas too. And I worked in paralegal work for a long time. Never would I ever. I mean, don't get me wrong. There are certain attorneys that do shit like that. And I'm not saying they don't, but generally, that's not something you're seeing in court, because to Law's point, that's not the person you want to piss off. Now, the attorney on the other side of you, maybe a little, but the judge, absolutely not.
Well, and most of these justices come from the civil world. Gorsuch was a corporate attorney. So the judges get used to corporate attorneys being assholes to them,
yeah,
and they're assholes right back. Criminal world is an entirely different thing. Your client's life is in the judge's hands. Every objection that you make is going to be ruled on by that judge. And it's very different than the civil world, where you can get a little bit snippy. The judge slaps both sides down. The prosecutors are going to be consummate professionals. They're not going to be pounding the table. They're not going to be doing anything like that. So the only thing you're doing is harming your client's chances at a fair trial. Now, should it be that way? Absolutely not. You should be able to vigorously defend your client, and it shouldn't change on that. But there's some practical realities that I think that happen in criminal courtrooms that are lost on some of these civil litigators.
Yeah, I know, I think at least to you, I know I've expressed sort of some of my discontentment that most justices, in fact, are have no previous work in any kind of defense. It's alarming, because I feel like you need some balance there, and it's kind of very aligned towards state favor, I guess I could say.
I mean, Alito was a U.S. Solicitor General, so he's always been on the government's side, arguing for the government. The only person there with any real substantial defense experience in criminal world, and not just corporate tax defense, criminal stuff, but actual criminal law defense is Jackson.
Yeah, and I want to get to her, because I bet her comeback is going to be great. I hope, anyway.
This court would find there's an unreasonable determination of fact, but under 2254A, of course, we can only grant a writ if we find a violation of the Constitution. So there's obviously more work to be done after we decide the waiver issue. Can you explain how that's going to proceed?
I mean, I think, number one, there would need to be a showing of a substantive, batson violation, potentially, overcoming E1, for example, in district court. If this court or the lower courts were to think that law and justice were shown in this case to warrant issuance of the writ, I think it would go back to the state courts. I mean, this would depend. If the court finds a substantive batson violation, I think.
Well, no, we're likely, assume we're not going to make that inquiry. We're going to confine ourselves to what we spent the last 2 hours talking about, which is the waiver issue, okay? And we find an unreasonable determination on the waiver issue, what more does a federal court need to do?
Got it. I mean, I think, as we've said in our papers, the possible remedy in that case, when it goes back down the federal chain, would be a writ that would
That was weird. My gifting was suspended for 10 minutes.
If the Mississippi Supreme Court does not in a certain amount of time
Said I did some
undertake
sort of
whatever analysis
violation.
this court holds to be lacking. So if that's do a new step 3 analysis in light of the relevant arguments, that would be the measured remedy there. I think that'd be consistent, for example, with what's appeared when, say, habeas is granted on a question of whether a confession was voluntary. You don't necessarily need to do a retrial. You just need to see if the confession was voluntary. If it is, things can stand. I think similarly here,
Justice Kavanaugh?
A couple things. First, I agree with you that the court does not need to do anything if at the point in the transcript we've been focused on, defense counsel had said, I withdraw my batson objection, or having heard the asserted reasons, I have nothing on pretext. So I agree with you in that situation, but that's obviously, as we've explored, not what looks like it happened here. You've said that she could have jumped in again after that colloquy on 175, after she twice
No, she
raises
fucking
it.
can't.
But at the end of
Jesus.
that, the district court says the court finds there to be no batson violation. Now, again, as Justice Kagan said, could have jumped in, but at that point he said, you've made the objections, you've preserved them, and there's no batson violation.
That part.
I agree with that framing because, again, made the objection, Your Honor. I think that's
We got
critical
the stutter.
And then for why, there are two possibilities for why I think it got truncated here, which we've all explored.
Yeah, Catherine, this
One
is an
that the
unaliving
trial
penalty case
judge
that
had
they're
a
trying to get
misunderstanding of
retried
what
because
Batson
there was
requires,
allegations
didn't understand
of
the third step, and that's in
racism
that
in jury
sentence that I read
selection.
before, well, all the reasons were race neutral as to members,
Or at least
and so
that's
there's
the
no
goal.
Batson violation. Right? So that's one possibility. The other possibility, and Judge Mills in the federal habeas district court alludes to this, because Judge Mills applies EDPA, correct?
He says he does.
Right.
I agree with that.
Yeah, no, but he articulates the EDPA framework. He's a very experienced district judge. He's been on Mississippi Supreme Court justice. He says he's applying EDPA unreasonable. And what he says happens
You
is
can be
it's
a really
stopped after two
experienced judge. It doesn't mean
steps.
you
Simply
know what
put,
the
no
fuck you're
state
doing.
court, whether it be the majority in the Mississippi Supreme Court or the trial court, conducted a full 3-step Batson inquiry. And then he explains what he thinks could have happened. He's generous to the trial court on this, I think. The trial court, seemingly eager to proceed to the case itself, quickly deemed the reasons as race neutral and moved on. The trial court's actions, perhaps understandable and relatable to this court, speaking to Judge Mills, trying to show empathy, I think, for the burdens on a trial judge, are error nonetheless. So I think, whether the trial judge misunderstood the third step or the trial judge was just, rushing it along to try to keep things moving or whatever, it just never happened. And that's Judge Mills, again, applying EDPA, or at least articulating EDPA. I agree with Justice Thomas completely. We have to look through the EDPA standards here.
And so I appreciate that, Justice Kavanaugh. To take the second bit first, I would come back to petitioner's own words where he declared on direct appeal that the trial judge did decide step 3. And this is surely a fair reading of that record. That's page 484 of the transcript. And he, again, links that to the same parts of the transcript that we do in footnote 4 on page 484.
I will be live
And
for Birthright
I think that's
Citizenship
quite
tomorrow,
important. I think
so
it
if you're
shows
wanting
that
to
it's
watch
not
that,
objectively unreasonable to find that the trial
like
judge
and
did
follow and all
conduct
the
step 3
stuffs,
here.
and
Could
I
it
will
have
be on
used
for
better,
that
more clear
tomorrow.
words? I think, of course that's true. But what I think the judge was really doing was he wanted to be clear.
I have to double check. I know Law's going to be here, and I believe Attorney Dye is going to come by as well.
That is surely a permissible view of the transcript, and therefore, on clear error and certainly on EDPA review, I think it is the compelled view in this case.
Last question, sorry to prolong it, obviously focused on this, but the reason this matters is this is a death penalty case, right? And he was 17 when he committed the crime, and he did not that this is good, but he was not the shooter, correct?
That's right, Your Honor. I mean, not the fatal shooter, that's right.
Thank you.
Whoa.
General Stewart, I just want to understand your answer to Justice Gorsuch on remedy. So if we think that the Mississippi Supreme Court was wrong on the forfeiture/waiver point, I don't understand how it gets back. You said something about it getting, you said this in your brief, something about it getting back to the Mississippi courts. Wouldn't the remedy be that we send it back down below for then the federal courts to analyze whether there was a Batson violation based on the comparative juror evidence?
Hey,
Okay.
that's what I said.
Yeah, this is where
I
we're
just don't
coming
see the
in.
route of
So
bouncing
she's
back. It's
giving
not
me a little
direct
bit
review.
of a
Well, I
different
guess
view
what
now.
So it would not be, we didn't suggest remand to state court straight from this court, certainly, Your Honor. I think we're responding to the suggestion that the writ should issue here at
How
all.
did they get a
My friend is making the
17-year-old
writ should
sentenced
flat
to
out issue ordering
unaliving?
release or
That's
retrial.
what's bothering me
And our view is
here.
that if a federal district court is issuing the writ here, the
I
most
mean,
it
I
can
know-
do
Case
is
was
in
certified
order that
as an
would correct
adult.
the actual violation, which by hypothesis here is not conducting a full step 3 analysis. And that could be something that is resolved by the state courts and would eliminate the constitutional.
So you're saying the district court shouldn't, if we sent it back down, I agree, we did not grant cert on the Batson question, so that's not for us to decide. But if we sent it back down, you don't think that the district court, or frankly, the Fifth Circuit, I mean, he said that
The Fifth
the court
Circuit
has what
will
it
do
needs in the record
anything.
to look at the comparative juror analysis. Why couldn't the federal courts make the Batson determination themselves?
I think that would also be an option. I mean, I think if you sent it back down to the Fifth Circuit and said, hey, look, you were wrong to find waiver, I mean, I think it would have everything it needs in the Fifth Circuit to just flat out rule on the Batson violation. As we said, you obviously know the
Fifth Circuit's never going to send that back for a trial.
Okay,
I'm going
thank
to call it now.
Justice Jackson, anything further? Thank you, counsel.
Fucking Solicitor General, goddammit. Hopefully it's quick.
Ms. Ferguson?
Mr. Chief Justice, and may it please the court. State and federal appellate courts routinely decline to consider claims, issues, and arguments that were not preserved in the trial court, consistent with historical tradition. The Batson context is a particularly important time to apply that rule. Whether a Batson violation has occurred is fundamentally a question of fact. Requiring parties
This
to
voice
preserve their
drives me
arguments for the
fucking
prosecutor's
nuts.
stated reason is pretextual.
And because,
Ensures that
and blah, blah,
trial courts
blah.
can
Like,
consider
I
all
can't
of the
do it.
relevant information as they make the factual determination whether discrimination has occurred. And it allows prosecutors to explain their strikes and decisions not to strike when the reasons are top of mind. Justice is better served when these questions are aired before the jury is sworn, when any errors can be fixed, rather than through a cold record on appeal. The Mississippi Supreme Court did not unreasonably apply federal law or unreasonably determine the facts when it determined that petitioner failed to preserve his Batson pretext arguments in the trial court. This court should affirm. I welcome the court's questions.
Well, Ms. Ferguson, would petitioner have preserved this argument, the Batson arguments, if he had been in federal court?
No, petitioner would not have, I think, preserved the arguments. The federal courts would apply plain error and consider those arguments under that standard.
What do you do with the points we've been talking about on page 175, where the defense
Is this
seems
Roberts?
to be looking down the road for something
Yes.
that's going to happen? Said at some point, I'm going to want to reserve these questions. And the judge does say, you've already made those, they're clear on the record. In other words, his response, the judge's response to I'd like to reserve them is that you have.
Well, Mr. Chief Justice, I think that was likely a demonstration by defense counsel that she wanted to say more, and she in fact did say more. And so that I'd like to respond to something that was of significant discussion during the state's argument, which is that reference on JA 176 to the statistics. And the fair cross-section requirement applies to the veneer, not to the selected jury. So when the defense counsel is referring to the number of black jurors who are on the selected jury, not on the veneer, that necessarily is an argument in support of the Batson claim. And
It draws
shouldn't
from the
be
same
an
issue.
argument in support of the
Shut
fair
up.
cross-section claim, because she's talking about the selected jury. And so I think the suggestion
No,
that
she
that was
wasn't.
only about the fair cross-section claim and not about the Batson claim just doesn't make a ton of sense. And I think it shows that she was in fact given the opportunity to raise additional Batson arguments, and she chose
No,
not
she
to
was
raise
not.
any
So
argument
you're-
as to jurors.
You're saying when she said at some point I'm going to want to reserve this, that was the half page of the record later?
I do think that's when she took the opportunity. And she could have said, you know, if I may, Your Honor, I have additional arguments to make. She didn't do that either before she said, I'm going to want to make, or after she said, I'm going to want to make.
In the federal courts, they already have plain error review, and counsel for the state tells us that the state also has the discretion to consider a plain error, correct?
That's right, Your Honor.
All right. So if the juror comparison is clear from the record that there was a Batson error, that could be reviewed and should be reviewed by the Mississippi court, no?
Well, I think 2 points on that. One is, you know, just the existence of an error being plain is not sufficient to make mandatory plain error review. And so under state law, the state court had discretion to consider that argument or not, depending on the other prongs.
If a step 3 analysis was never done by the court, how could
it
not be an abuse of discretion to fail to have done it by someone? It's a judicial obligation to do a step 3.
Did they send their newest attorney to make this argument? Because this is dog shit.
To say that the trial court here did not make a step 3.
I know we're going back and forth on that point.
And I'd add one more response on that.
Counsel. Oh, go ahead.
I'd add one more response on that as to the existence of a step 3 finding here. And that's in this court's decision in Perquette, the court said that the state court had found at step 3 that the prosecutor was not motivated by discriminatory intent.
Aggressive.
The way the court describes the facts in that case is that the state trial court, without explanation, overruled respondent's objection and impaneled the jury. So I think that's very similar to what happened here. And the court found that there was, in fact, a step 3 finding, even though there was no explicit, I find the prosecutor's stated reasons to be credible.
How could there be a step 3 finding if usually that's evaluating whether the race-neutral reason is the true reason or whether instead it was pretext? If there has been no argument that it's been pretext, how could there be a step 3 analysis? That's point 1. And then point 2, Judge Mills, who evaluated this, the federal habeas court, flat out said multiple times it ended at step 2.
Well, Your Honor, I don't think that Judge Mills was right to say that it ended at step 2. And I know you pointed out earlier the state court's line that all the reasons were race neutral. I think that saying all the reasons were race neutral to Justice
Maria,
Alito's
birthright
point
citizenship will be in the morning. We'll be on tomorrow.
Had found those to be the actual reasons. You don't have a situation where the trial court said the prosecutor stated race neutral reasons, and so we find there to be no Batson violation. That would look like a state court that was misunderstanding what Batson requires at step 3. If the state court said that only stating race neutral reasons was sufficient. But here you had the state court say all of the reasons were race neutral. And I think that's enough, particularly given what this court found.
No, the fuck it isn't. Not if you.
There was an implicit credibility finding there.
I'm going to lose my fucking mind.
All of the reasons were race neutral, and so the court finds that there to be no Batson
Clock it,
violation.
Jackson.
Justice Jackson, I think the answer is the same, and that's because, again, if the reasons are race neutral, that implies that those are the actual reasons, and that's distinct from saying the prosecutor has stated.
But isn't that collapsing 2 and 3?
If you give a reason, it's a reason.
Reasons. 3 is
fucking, I
are
swear
they
to God.
Pretextual, and we've said you aren't supposed to collapse those 2. So your argument just did so by saying if you have 2, then you've satisfied 3.
Justice Jackson, no, I don't think that that's our.
You didn't just say that if they're race neutral, then that means they are the real reasons?
I think if the actual reasons are race neutral, so not whether the stated reasons are race neutral. If the prosecutor has merely stated race neutral reasons and the trial court doesn't credit those reasons, or if there's any reason to believe that those are not the real reasons that the prosecutor exercised the strikes, then you could have.
Isn't there also a more complex way of looking at this that Miller L. brings up, which is not reason by reason, but sort of the comparison? Right? There's no indication here that this court did any sort of comparative work, which would have been what we would have expected from the district from the defense counsel if given an opportunity, correct?
I think certainly given what defense argued on appeal, you would have expected that.
Right. So if the comparison is also a part of the determination of pretext, how does this record indicate that the court did any of that kind of analysis?
Well, I don't think that there's any particular indication that the court was sua sponte considering arguments that weren't raised. But I think that when it comes down to the ultimate question, this court has explained several times, the ultimate question is whether the prosecutor or the striking party was engaged in intentional discrimination. And necessarily, if the judge finds that the reasons were race neutral, then race neutral reasons, in fact, being exercised is incompatible with a finding of intentional discrimination.
Can I ask you a broader question, and then I'm done? The United States has entered this case as an amicus curiae, meaning that you did not have to be here. And as Justice Kavanaugh pointed out, this case is a capital case involving the conviction of a defendant who was not the shooter, a felony murder scenario. And so I guess I'm trying to understand the United States' interest. Your brief doesn't really pay a lot of attention or devote a lot of time to defending the actual conviction. So what is the principle that you are seeking to have upheld?
They
in this
want to
case
be able to
bypass
that
defense counsel said several times, I
and
have
just do whatever they want with juries.
to preserve it in the court. If anything, misled her into believing that she had preserved it by saying it's in the record. Why is the United States interested in being involved in this case?
Well, Your Honor, the United States is a party in many trials, including many criminal trials, is subjected to Batson objections and defends in Batson cases. And
there it is.
I think our interest is in defending the right of courts of appeals to exercise their discretion to consider juror comparison arguments and not, as I think petitioner, if I may, Your Honor,
sure.
Not as petitioner argued in petitioner's brief, although it seemed to walk away from today, adopt a rule that appellate courts must consider juror comparison arguments when they are raised for the first time on appeal.
Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Kagan?
Ms. Ferguson, I want to go back to what you were saying before, and I'll grant you something. I'm going to assume your view that the judge here did not collapse Stage 2 and Stage 3, and the judge understood what he was doing, and that the judge made a determination that there was no Batson violation, the determination that you would make at the end of the day. Right? And in exchange for my assuming your view on that, I need you to assume my view on something else, which is that the defense counsel understood that that's the stage that they were in. In other words, that now they were talking about the ultimate Batson violation, and what she was objecting to was the finding of the ultimate Batson violation. So let's say that they were both on the same page. We understand that we're contesting the ultimate Batson violation. So if you assume those two things, and the court says there was no violation, and the defense counsel says, I object to that, I think there was a Batson violation, and he said, I got that, I understand that, it's preserved. And she says, I want to make an argument about this. And he says, it's preserved, it's preserved. How could it not be preserved?
Well, Your Honor, I agree with the state that there's a distinction between preserving a claim and preserving particular arguments, and simply saying, I disagree
oh my God,
with the
they keep
finding
playing this
is not
fucking
sufficient to
semantics
preserve
game. It's driving me
every possible
nuts.
pretext argument under the sun. And so I think there needed to be some form of even gesturing at juror comparisons. There was nothing in the record at all until after trial to suggest that petitioner's counsel thought that there was a problem with white jurors not being struck who shared
dog shit. That's dog shit.
So you think in the face of the court saying again and again, it's in the record, I got it, it's preserved, she has to make clear what the particulars of her view is, why exactly there is a Batson violation?
In order to preserve those particular pretext arguments for appeal, yes, under Mississippi law.
Thank you.
Justice Gorsuch?
In fact, a lot of courts have issue preservation rules with respect to arguments, not just claims or issues.
That's correct, Your Honor.
And we've never held those impermissible before.
No, Your Honor, and in fact, this court has repeatedly reaffirmed, both in the context of Batson claims in state courts, in Batson and in Ford versus Georgia, the court has reaffirmed that procedural rules are permissible. And then in Singleton versus Wolf, this court affirmed that courts of appeals in the federal system have discretion over when to accept unpreserved arguments on appeal.
This is a place of disconnect. I just,
is it unusual for the United States to appear as an amicus when we have a constitutional question?
There's only so much an attorney can do.
The United States in litigation?
No, Your Honor, it's quite common for us to appear.
Thank you.
Justice Jackson? Thank you, counsel. Rebuttal, Mr. Perkovich?
Just a few quick points. First, I want to address the issue with may not in the Woodward case that constrained on direct review the inquiry. And that's simply the point. At that gateway issue, there was an understanding that they clearly may, and this court has done so routinely. So that's our fundamental point on that. With respect to the procedural rules that Ford versus Georgia endorse as a basic principle, we have no qualm with that. That is a timely objection rule. Of course, that's not applicable here. And with respect to a waiver rule and forfeiture, however it's framed, the problem is that it's not implementing Batson in Step 3. It's obstructing Batson in Step 3. And that's the work that's occurring in this case and the problem with that rule. With respect to the conflation of race-neutral findings and Step 3, there is a very big step between determining something's race-neutral and determining it is credible. And that's where the work of the court, at a minimum, the trial judge, is required. Whatever is being pressed by the opponent of the strike for the reasons I pointed to and are spoken to forcefully in Powers with regard to the other stakeholders and the broader stakes for our society with regard to the Equal Protection Clause in this context. With regard to remedy, Batson, of course, ushered in a prohibition of the discriminatory use of strikes in a way that improved upon Swain and provided a specific framework. And so when that framework breaks down, as it did here, that's a structural error. And so this has to return to its prior posture, in much the way the last time this court found a D2 violation in Miller L., which is to the district court and for a judgment entered for the petitioner.
Thank you, counsel. The case is submitted.
Sorry, I just wanted to turn my window off because I don't think they have another case scheduled. Law, if you're up for it, there's just two things I want to go back to, just kind of reviewing what we thought about this. And then a couple of people had asked to just kind of highlight what we were talking about earlier with the Chiles v. Salazar. Is that cool?
Let's do it.
All right. So thoughts on what we just heard?
Yeah, it's a tough one to call, and the unfortunate thing is, you know, they didn't grant cert on the was there actually racial discrimination? It was very much the procedural aspect of that, and so the actual outcomes kind of get lost. And in my mind, it's just like, if there's a hint that the procedure wasn't followed, you're talking about somebody's life. Let's just go back and do it again. If there's at least a reasonable grounds to believe that there was an error, when this is the DP is irreversible. It's not something you can come back later and be like, oh, you know what, maybe we did screw that up. So yes, it's annoying. Yes, it's time expensive, but if the court potentially made an error and we're arguing about whether or not there was a pause in the transcript or not, I think we're losing the forest between the trees here. There's somebody's life at stake. Let's make sure that things were done right.
Yeah, so I kind of, I'm feeling like Roberts is kind of going to be the decider on this. Coney Barrett kind of like went both ways with it, but he felt like she was a little bit more probing the petitioners. I felt like she probably will land in the camp with like Alito and Thomas. And it's unusual. I don't usually see her there. It's kind of a flip flop for me because I feel like Kavanaugh is sitting with Kagan, Sotomayor, Jackson, who all seem to kind of be on the same page that like we're saying like there's a fucking error here, right? I think like Roberts is kind of where I'm at, where I'm like, I don't know which way he's gonna go. But again, like to your point, it's very procedural, so it could get lost and maybe I'm just reading it wrong, but that was kind of my vibe. But I agree with your point. Obviously there was an error made. Like I don't even think we can dispute that. And to me, when you're talking about somebody's life, just a new trial. Like why not? You know? I mean, I think it's super problematic. And I just really I hope that's the outcome for this.
I think if they were to send it back to the Court of Appeals to assess whether or not the Batson challenge was effectively raised, I think they could get 5 or 6 on that. If it is no, there's the Batson challenge wasn't procedurally handled correctly, and we need a new trial, that might be only 4 there, maybe 5. So I think that's what it may hinge on.
Well, let's just explore this for just a quick second. Likelihood that the Fifth Circuit is going to be like a Batson challenge was
Right.
like.
But also that it would be a very SCOTUS-y thing to do, is to be like, well, let's send it back down and let them analyze it, and then maybe we'll have to take it up next term again.
Yeah.
That would be a very SCOTUS-y thing to do the kind of the minimal work necessary to and not create an overreaching opinion.
Yeah, I mean, you're right on that. I just feel like if there's a clear error in like, blatant procedure, like don't even send it to the like I would just retry it. But again, that's my thing. But I do see what you're saying with SCOTUS and everything like that. Somebody asked me in the chat if I was going to go to law school. I am slowly studying for my LSAT, but my mouth may be the unaliving of me. So that may not be what I end up doing, but I had a fire in my house, and so I'm slowly recovering from all that. Life is just busy, but so. Did you have any other thoughts on it, or do you want to move over to Chiles Salazar?
Nope, we can go back.
Okay, so we got a ruling today in Chiles Salazar where they said that Colorado's law, the way that it was structured, is restricting this therapist's First Amendment rights. I don't agree with the outcomes. But law sort of made a convincing point on the way that they did it. And I wanted to let him talk about that.
Yeah, kind of the key issue there is it comes down to viewpoint discrimination. So states are allowed to restrict the speech of, in this case, medical providers, therapists, as long as and they can be content restrictive. So you can say that, you can be restrictive, so you can't say this thing, but it has to be viewpoint neutral. And so the issue here is that the specific language that was used in the Colorado law only allows therapists to do acceptance, support, and understanding and assist with transitions. So when we're talking about that, if a therapist has a viewpoint that's not that, they're essentially being told they can't practice. And that's where it gets problematic. And I compared this to Minnesota's law that says that so long as it does not seek to change. And that's actually a more of a in line with professional conduct restrictions. And it's not even telling you what you need to change. If somebody comes in and says, "Hey, I feel like I'm a, if it's a biological, male says, I feel like I'm a woman," as long as your therapy doesn't seek to change that, you're free to kind of enter those discussions and have that, offer countering views. I brought up an example: if a 6-year-old comes up and says the same thing, a therapist would be able to say, "Well, are you sure about that? Tell me about your feelings. Have you thought about this?" In Minnesota, whereas in Colorado, the only thing that therapists are allowed to do, regardless of their viewpoint, is to offer acceptance, support, and understanding, and then assist them with the transition. And so that, I think, goes one step too far. And they did bring over Sotomayor and Kagan on this as well. So it was not, I think it would have been, 8-1, right? There was only one dissent, Jackson? Yeah.
Yes, correct.
So I think that's where you're starting to get into viewpoint territory, where you're saying, regardless of your viewpoints, you have to do acceptance, support, and understanding. And that's where the issue lies. So Colorado can come back and tweak the law a little bit and likely avoid the issues that were raised in this case.
Yeah, I think that's something important to indicate here, is that they're not just saying like, you can't, like, states can't make laws on this at all. Like, and I think that kind of gets like a little bit bypassed here. They're just saying that the way the law is framed, it's a strict scrutiny when you're talking about the First Amendment. And that's what this case was really judging, is like, where are we seeing this under? And like, I think to Law's point, they can sort of reshape the way that they do that and get it passed, and then still have protections in there. Am I wrong?
And I'm already seeing some headlines, like AP already had a headline that Supreme Court strikes down. What was the headline? It was a little bit misleading. Supreme Court strikes down conversion therapy ban, which it didn't do. It struck down Colorado's law as viewpoint discrimination. So I hate headlines. They almost always get legal things wrong. They're far more nuanced than a headline typically affords. But even that framing makes it look like that conversion therapy is banned, which it ostensibly is not.
Yeah. Oh, speaking of misleading headlines, I didn't say we were going to go into this, but I remember somebody asked in the chat earlier, and it was the same question I sort of posed to you last night, because I didn't deal with a lot of, firearm stuff in at least on my end when I was in federal. They were asking about the bullet in the case, and you had a really great way of explaining to me that this is kind of, a little bit more common than people think, and it's not as groundbreaking in the CK shooter case, where I sent you that thing about, there wasn't a ballistics match, basically.
Yeah, I mean, that science is mostly garbage. The best that you can kind of hope for is that there's a metallurgical match, meaning the metal that was identified in the bullet was consistent with metal that had been fired out of the firearm. But there's a whole lot of problems with that. Is, you don't know when that metal was deposited. The vast majority of ammo suppliers use the same types of metals and the same ratios, so you can't definitively say that it's going to match. But also, high velocity rounds like that get very mangled and very altered when they're fired. So it's virtually impossible to say with certainty that a particular bullet was fired out of a particular gun, unless it's just perfectly preserved, and you've got the lands and grooves of the barrel with unique enough markings that aren't consistent with, if somebody had a particular dent in one of the grooves in the barrel and it matched with the bullet. Like, you have to get super specific. It's very rare that you're able to definitively tie a particular bullet fragment to a particular firearm.
Well, and see, that's what I was thinking yesterday. I hadn't mentioned it to you, but yeah, like it's a high velocity round. Like I would imagine, I mean, just generally, firing into like you're going to do some damage, right? Like, I mean, if it's like a person or an object and not just like, a sheet on the wall kind of shit. But yeah, you're going to do a little bit of damage and like the bullet tends to get a little mangled. And I was curious about that. I'm glad that you touched on it. Thank you. You can still know what caliber the round is and what, yeah, but that, like, okay, Migas, like, that's not the only thing they're looking at when they're saying they can't tie the bullet to a gun. It can still be the same caliber, like, that's not a conclusive
the most
finding.
you can get with is it's consistent with, you can't get a definitive evidentiary tie, that like a DNA match to a person, there's nothing like that you get, because a 308 and all of them use 30 caliber bullets, so 30-06, 308, 300 blackout, I forget which type of firearm he used. It was a 30 caliber Mauser. All of those can use the same types of actual bullet. The cartridge itself is a little bit different, and that's a different thing. But the actual projectile can be common among numerous different calibers.
Yeah, that's interesting. Like and I wanted to touch on that because we were talking about, the misleading articles and like, this happens a lot, like particularly within the legal system. I will tell you to go read documents. I will tell you to go read, the case, because I see this a lot, and it doesn't help anybody if you're not representing accurate information. Like I think the comment I had gotten earlier, and this is not an attack on anybody. Like this is not anything like that. I want to be clear. Was that there was like some big finding in the CK case and they were asking about it, and like it really wasn't that big of a finding. It was just the way that it was framed in the articles that came out. And that happens quite a bit. Like to Law's point earlier about the AP article about Chiles v. Salazar misrepresenting the crux of the case. They didn't say conversion therapy was okay. None of those things were said. What they said was, hey, the way this law is crafted, it restricts this therapist's First Amendment rights. Do better. That's basically what they said. I mean, that wasn't the like actual decision, but like that's what comes out of this. They didn't say like, oh, you can't, say conversion. They didn't say any of that, at least from my understanding. Am I correct on that?
Yeah. It was very specific to the language used in the Colorado bill. So it's not a broad sweeping opinion. It doesn't strike down any other state like Minnesota's conversion therapy ban, because it was very specific to the language that Colorado had passed.
Gotcha. All right. Well, if anybody has any questions, I guess throw them in the chat real quick. Otherwise, I think I'm going to get off here and maybe adult a little today. It's a high bar. I don't want to do it though. But Law, thank you so much for coming up. I really appreciate you. I think we're going to be live tomorrow for Birthright Citizenship.
Yes, I should be. I might not be camera ready, but I'll be there for the arguments.
How can you not be camera ready? I'm so hurt. No, I'm just kidding. I'm
not going to be at home or in the office, so I might be sitting in my vehicle.
Oh, I gotcha. Okay. Yeah. So we'll be live tomorrow for the Birthright Citizenship argument. That's going to be a bigger case. I believe Attorney Dye is coming by as well, because we had talked about that earlier. So thank you all so much. Law, I love you so much. Thank you for being here. And I want everybody to have a great day. Bye, guys.